Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. I must tell you to like, subscribe, comment down below, and share our videos somewhere else because apparently that's how our channel grows. And we have a question here from YouTube user Aid Ahead, who I give a Muppet Swedish accent to, apparently, to your name now. Aid Ahead. Aid Ahead. I don't know why I'm doing that. I apologize. I don't know how to say your name, and I'm sorry. Your username, right? Aid the Head asked us, do you have a video about a pro se forming motion summary judgment after discovery is closed? Even to have judge narrow the scope. I had 11 claims in my complaint. Thanks. Okay. So I think what you're asking me, there's two ways to approach a summary judgment motion, right? Normally, in employment cases, if you're dealing with workplace discrimination, workplace sexual harassment, normally what you'll see is the defense attorney making a summary judgment motion to knock out some of the plaintiff's claims. And then the plaintiff will have to oppose that summary judgment motion, proving that on all of those claims, or at least some of those claims, there are legitimate questions of fact that you can bring to trial that should be heard by a finder of fact, whether it's a judge, jury, arbitrator, whoever it might be. That's the norm in our field. Now, certainly there's cases where my firm says, we think we got this, we don't think we need to go to trial, let's try to win this in summary judgment. And sometimes that works. And sometimes you can even win certain claims and you get like a leg up, but you still have to try other claims. There's different ways that can go. And essentially what a summary judgment motion is, and I have videos on the channel about this, is you saying, hey, based on what we have so far, there's no question of fact here. We know what happened, and it either definitely fits the elements of this claim that the plaintiff is trying to prove, or even if you accept everything the plaintiff is saying as true, even if you assume everything they're putting forward is true, they're not going to be able to win this, right? There's not a legitimate question of fact. It can't be won. And if it can't be won, then it's extinguished. That claim does not go forward to trial. Other claims, right? You may have like 30 claims. Probably not 30. It could be 30, certainly. Let's call it 10 claims, because I think Ada Head says 11 claims, right? So out of those 11 claims, 8 might survive, hypothetically, if the defense is making a summary judgment motion. Now, that's normally here. The plaintiff would normally, again, be defending, would be opposing the summary judgment motion. And that, even opposing, being reactive and opposing a summary judgment motion is incredibly difficult for a pro se litigant to do. It is hard because you're a lot of times you're going to need legal research. And that's going to be very daunting for a non-attorney in this field. That's what it comes down to. Now, I don't think, based on this question, that that's even what Aid the Head is asking, because it sounds like Aid the Head is asking us if she or he can make their own pro se motion for summary judgment. And I'm a bit confused because Aid is saying, I want the judge to narrow the scope. I had 11 claims in my complaint. I want to narrow the scope. Generally speaking, the plaintiff wants as many of his or her claims to go forward as possible to trial, because that's the most opportunities to win. So you're trying to safeguard as many claims as possible to trial. You probably don't want to narrow the scope unless Ada Head is saying that she or he believes some of those claims might be won outright and might not then need to proceed to trial, in which case I certainly understand why you would make the motion for summary judgment proactively. Although I will still say that I think that is an incredibly tall order for a pro se litigant. And without being too negative, I don't know that I have ever met a pro se litigant, and I've met some pro se litigants. They're incredibly rare, but I've met ones who do a very good job. Like they got their case where it needed to go, right? There's a YouTube channel where a pro se litigant did an amazing job against NASA, right? Like she did it. She made it happen. She got there. Even and the joke I make every single time I talk about her is, I don't actually know if she was a rocket scientist, but like you can extrapolate. It takes a rocket scientist to get that done. Like the depth of research and knowledge required to be a pro se litigant and do that is incredible, right? So yes, people do it. It is incredibly rare. And I don't know if I would actually suggest in federal court making a pro se motion for summary judgment for a pro se litigant. That seems like adding an incredible burden of work and complexity for the pro se litigant that might not be required. I can see the draw because you're hoping to not have to try the case. And trying the case can be very daunting, especially if you're not like a comfortable orator, right? Whatever. But it seems like it's just adding 60, 80 hours of, for a pro se litigant, that's what I've seen attorneys spend 60 to 80 hours on summary judgment motions. I don't know what a pro se litigant might spend because they, in many ways, are going to be reinventing the wheel. There's a lot of concepts, a lot of law they're not going to have at their fingertips. They're probably not going to have a tab full of old case law that they can pull from for general notions in this field. Like that's not something that's going to be at their disposal. And that's something firms build up over time, right? You have the case law that supports the positions that you want to make, and individual attorneys and firms are going to have set case law that they then, shepherdize, which means to like check to make sure it's still current, that they use when making legal arguments. And that's going to be incredibly useful in a summary judgment motion. And a pro se litigant's not going to have those things. They're not going to have those shortcuts. They're going to have to reinvent the wheel for every single thing they're trying to argue on a legal basis, right? So, that's hard. Now here, Aid the Head has said that she or he wants to narrow the scope. If you're the plaintiff, I don't fully understand why you would want to narrow the scope, unless, again, you think you're going to win some of these claims outright on summary judgment, in which case I do get that. But it just seems like you want, at least I would want, in your shoes as a plaintiff, as many claims going on to trial as possible, because that gives the opportunity for the jury or the judge, if you're having a bench trial, or the arbitrator to find for you. They have more opportunities to find for you as you're going down the list. They can say, well, I don't think this happened. I don't think this happened. I don't think we met the elements of this claim. But this claim down here, number 9 out of 11, I do feel strongly that was in play here based on what I saw at the trial. And I feel the defendant is guilty. And frankly, in many situations, any one of those 11 claims could give you access to the full, or at least most of the full potential body of damages, right? So you could hope to win the same whether you prove 3 potential claims or 1 or 11, depending on what the claims are. Obviously, there's specificity. There's differences between different jurisdictions, state laws, local laws, and federal laws. There's differences even in the federal laws. There's some variety of how the damages are calculated in different claims. But generally speaking, it would be entirely possible to win 1 claim or 3 claims or 11 claims and have access to roughly the same pool of damages. So you then would want the most opportunities to win to go forward, and that could be really helpful for you. So I'm not, and I don't think, Aid the Head, that you're wrong. I think perhaps we're miscommunicating and I don't fully understand what you're trying to say, or just that you're very confident and you think you could win this in summary judgment, or at least win some of the claims in summary judgment and have less burden at trial. In which case, if you really believe that, like, I understand where you're going with this, and if that's informing your decision making, well, I'll be over here rooting for you, hoping for the best. If this was helpful, like, subscribe, comment down below. It helps me to help more people just like you. And I'm supposed to tell you to share the video. Share the video, because that's how our channel grows. Helps us to help more people. Again, just like you. Just like you. All right, everybody. Take care.